Happy Friday! I am here again. I'm still working on finishing up the other video. Like I said, some few technical difficulties, but I am so very grateful for everyone who still wants to hear my perspective on this and is understanding of my limitations and is still encouraging me to post. I want to be clear again that this is not what this channel will solely be about. It's just so many updates are happening that it kind of is all consuming at this point. And this, with the most recent video I put out about the breaking news via Dave Neal, someone corrected me that like Dave Neal has never said her name, and that's true. I am saying her name though, so please don't get that twisted on Dave Neal's behalf. We don't want any trouble for him. But this just in, here is the petitioner's response to expedite a motion to extend dismissal date on inactive calendar and schedule an evidentiary hearing by Alexis Lynn Vall, who is one of the two new lawyers for Laura Owens. She is also a self-proclaimed Bachelor fan if you watched Dave Neal's video, which is very interesting. Okay, let's dig into these new motions filed by Laura Owens and her new attorney. I'm going to start with the petitioner's motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice. Now, this is filed with one of Laura Owens' two new attorneys. This is Alexis Lynn Vall. Petitioner Laura Owens moves this court to dismiss her petition to establish paternity, legal decision-making authority, parenting time, and child support, filed August 1st, 2023. Petitioner is not now pregnant with respondent's children. Under ARS 25801, this court has jurisdiction to establish maternity or paternity. Here, there is no paternity or maternity to establish, as petitioner is no longer pregnant. Accordingly, this case must be dismissed. Very fascinating. No longer pregnant. There is no paternity or maternity to establish. Almost like, I wonder if there was never any paternity or maternity to establish, allegedly. 1. Factual background. The underlying petition was filed on August 1st, 2023. Respondent filed a response on August 21st, 2023. On December 27th, 2023, petitioner's counsel sent respondent's counsel a draft stipulated motion to dismiss with prejudice. Respondent does not agree to the dismissal and instead seeks to utilize family court's resources for a case that does not involve a family. And that is just so funny to me because she has been swearing up and down that there was an imminent family. But now, it is very clear to me that she is feeling backed into a corner and now is miraculously no longer pregnant. I'm a little disappointed. Yesterday when I put out that video, I had been hoping that there was some kind of accountability, but instead it seems that it is the lawyers covering for her. And maybe, obviously I feel like if she signed off on her lawyers to submit these motions, that she agrees with the contents therein, which means she also agrees she is not pregnant. This still doesn't absolve her of any apology or admittance to wrongdoing that I really think is necessary in this situation. 2. Legal argument. Because respondent has filed a response to the petition, this case may be dismissed only by party agreement or by a court order. And because respondent does not consent to a stipulated dismissal, petitioner requests that the court order dismissal pursuant to Rule 36A. A. The family court does not have jurisdiction to hear a case involving unmarried parties without a minor child. And I find that interesting. Of course, he wanted a continuance, and they're saying, well, we can't have a continuance because there's no reason for this to be in court. And it's like, maybe there was no reason for this to be in court in the fucking first place. ARS 25801 grants this court original jurisdiction in proceedings to establish maternity or paternity. Here, there is no maternity or paternity to establish, as petitioner is no longer pregnant. Accordingly, this court no longer has jurisdiction, and the underlying petition must be dismissed. I wonder if this court ever actually had jurisdiction. That was my question. Additionally, it is well established that courts cannot decide moot cases. A case is moot when it seeks to determine an abstract question which does not arise upon existing facts. Because petitioner is no longer pregnant, this case is now moot and there is no need for this case to proceed. B. Respondent's only potentially viable claim is for attorney's fees, which he did not personally incur. On December 12th, respondent filed a motion for leave to amend his response. The proposed amended response requests the following relief. 1. An order of non-paternity. 2. An order compelling RavGen Inc., a non-party, to produce fetal DNA records. 3. Rule 26 sanctions against petitioner. And 4. Attorney's fees from petitioner. Items 1 and 2 are now moot because petitioner is not now pregnant. Regarding item 2, the request for relief of a response is not the appropriate place to request a court to order discovery from a non-party. As to item 3, respondent failed to comply with any of Rule 26C's prerequisite requirements. Specifically, respondent did not attempt to resolve the matter by good faith consultation as provided by Rule 9C. Even if he had tried to resolve this dispute, respondent did not provide the opposing party with written notice of the specific conduct that allegedly violates Section B. Additionally, sanctions cannot be requested as part of a response or of any other pleading for that matter. Pursuant to Rule 26C3A, a motion for sanctions must be made separately from any other motion. Respondent also failed to attach a Rule 9C good faith consultation certificate and or attach a copy of the written notice provided to the opposing party under subpart C2B. Accordingly, the only remaining viable claim in this entire case is respondent's claim for attorney's fees from petitioner. Respondent, however, crowdsourced his attorney's fees through GoFundMe. Exhibit A, Mr. Echard's GoFundMe. Respondent did not personally incur attorney's fees, and it is doubtful that he intends to reimburse all 331 people who donated to his quote-unquote cause. Respondent could easily have no attorney's fees moving forward if he agrees to the requested dismissal. Any fees incurred moving forward are a result of respondent attempting to inappropriately utilize the family court's resources for a non-familial dispute. The irony. Oh my god. The fucking irony. The potential irony. The alleged irony of that. Anyone else dying about that last sentence there? Attempting to inappropriately utilize the family court's resources for a non-familial dispute. In my opinion, the non-familial dispute originated, potentially, allegedly, with Laura filing this court motion to begin with for paternity of ghost twins. Oh my god. The shirking of responsibility just doesn't end. I mean, I know this is her lawyer, so she has to do these kind of things, and she's doing her job. Well, trust me, Alexis Linval, killing it. It's just frustrating because, you know, the court is only allowed to see what they deem as relevant information, and a lot of the times this contextual information gets lost in between, you know, evidence submission. And that's a shame. You know, the court will not see a lot of the information that we have. Wherefore, petitioner respectfully requests this court dismisses her petition to establish paternity with prejudice because the family court does not have jurisdiction over any perceived remaining issues. Respectfully submitted this 28th day of December. And attached, of course, is a screenshot of Clayton Echard's legal fund as organized by the one, the only, David Neal. Let's go over this petitioner's response to expedited motion to extend dismissal date on inactive calendar and schedule an evidentiary hearing. Also filed by Alexis Linval on behalf of petitioner Laura Owens. Petitioner Laura Owens asked this court to deny respondent's December 13, 2023 motion to extend in its entirety. In his motion, respondent requests 1. A 60-day continuance on the dismissal calendar. 2. A virtual evidentiary hearing on paternity/non-paternity attorney's fees and Rule 26 sanctions. And 3. An award of attorney's fees and costs pursuant to ARS 25-324. This court should deny all of respondent's requests. First and most importantly, petitioner has concurrently filed a motion to dismiss her petition to establish, filed on August 1st, 2023. In that motion, petitioner concedes that she is no longer pregnant. Without minor children linking these unmarried parties, this court does not have jurisdiction to proceed in a paternity establishment matter. And it's such a shame, of course, from my perspective, from what I know, that this can all just be dismissed. And she's no longer pregnant. And that's that. That's that on that, folks. Wrap it up. Pack it up. It's done. And I was looking through some people's responses as to how this can just happen, and people were saying that it's incredibly rare for people to want to drag this shit to court because the women who do this crazy shit, which is a very, 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 very small minority, don't usually drag it to court they say that they're pregnant to try to trap a man, and then something falls through, or something shakes out, and it is all revealed that it's not true. But it's very rare that this gets dragged to court, which I can understand. Family court really isn't usually used in these matters, but we're talking about someone with time and money and a vengeful attitude. This is what we might have in the situation. And the court is not prepared to, especially in the family court, is not there to establish if someone is pregnant or not. And it's probably not ever going to be a thing because it's so rare that this kind of stuff happens. It would be a procedural nightmare to get this, included over time when the, rate of occurrence is so low. I hear that. It doesn't make this suck any less. It does make me hope that there is a civil matter that will be opened beyond, the orders of protection and injunction against harassment. Second, respondent's motion is premature. The dismissal calendar deadline is not until February 2nd, 2024. It is not clear why respondent, who adamantly denies he impregnated petitioner and has stated he wants nothing to do with her, is seeking to ensure this case is not dismissed long before the dismissal deadline. But in any event, one unavoidable fact remains. Petitioner acknowledges that she is no longer pregnant with respondent's child, meaning there is no paternity to establish. There is nothing left for this court to adjudicate, and this case should be dismissed. The potential for this to be just such a cowardly bow out just sucks. It really does suck. And I'm hoping Clayton is able to really hammer this home, because this can't keep happening. This can't keep happening. Miraculously not being pregnant after dragging these men's names through the mud and taking them to court. It's so sick. It's so wrong. It is an entitlement to these men's time and effort and attention when they've already rejected you. And rejection hurts, but we've all got to lick our wounds and we've all got to move on. And the appropriate way to respond to rejection is not by going full scorched earth and ratcheting it up to the most dramatic result that could be possible when you're being rejected. And by that I mean, if you've been rejected, I feel like the biggest upset that could be to that rejection is, oh, you've rejected me, but guess what? Now I'm pregnant and now you can't get rid of me. That's just my opinion. It appears so vengeful and dirty, and it really just unsettles my soul. Third, given petitioner's acknowledgement that she is no longer pregnant, the only remaining issue is respondent's request for attorney's fees that, upon information and belief, he did not personally incur. Respondent's request for Rule 26 sanctions against petitioner is not viable, as respondent did not satisfy any of Rule 26 prerequisite requirements. For instance, respondent has attempted to shoehorn his request for sanctions into his proposed amended response and his motion to extend, even though Rule 26 clearly requires a motion for sanctions to be made separately from any other motion after a good faith consultation, which has not occurred. Wherefore, petitioner asked for this court to deny respondent's motion to extend. Petitioner is not now pregnant. There is no longer a paternity establishment case, as there is no paternity to establish. The case is now moot, and for this reason, petitioner seeks to voluntarily dismiss this case. Petitioner has concurrently filed a motion to dismiss her case in full, and this court should grant the motion and deny respondent's request for unnecessary hearings. Respectfully submitted this 28th day of December 2023. Very, very interesting stuff, folks. I'm really curious what everyone is thinking. I personally am very interested to see what this means for Laura's next steps. It's interesting because I felt like things were really reaching like a fever pitch, intensifying things, and all of a sudden it breaks with this announcement that she's no longer pregnant. I had been thinking, maybe this was someone close to her that was reached out to Dave Neal, but I'm thinking, of course, now this reliable source was really just the court documents themselves that Dave Neal was responding to. I don't know what I was thinking. Let's give it up for Holiday Brain. Here, me thinking that the woman who stated she's barely left the house has somehow been seen by someone who's a friend or something to say, hey, she's no longer pregnant. That's not the case, as we're now seeing, because the no longer pregnant is directly cited and quoted from these documents. I'm really interested to see what Clayton's attorneys will do next. If there will be any civil motions, I think of things like Gabby Petito and Brian Laundrie, where the court system denied to press any criminal charges, but the Petito family was able to drag the Laundries to court, and they have all this discovery that has came out that we never would have known, and the Petitos never would have known, had they not got the Laundrie's civil case going. And I think that's intentional infliction of emotional distress, maybe, or something along those lines. Again, I'm not a lawyer. I'm just kind of speaking from my memory, which is poor. But really curious to hear what you think about this. One of the commenters in the past video I uploaded mentioned, oh, this no longer pregnant is really a caveat. It's kind of a loophole. And I totally agree. It is, because it doesn't admit that she was never pregnant. It just says no longer pregnant. For Clayton, to me, there's a vested interest to be like, well, if she's no longer pregnant, this woman said that I was just the father of her children, undoubtedly. All these weird things have been going on. I haven't been able to get fetal DNA of my supposed offspring tested. And now no longer pregnant. So what does that mean? Did they just evaporate from her womb? Are they ghost twins? Everyone has already pointed out the fact that in Arizona, after 20 weeks, it's considered a stillbirth and it requires death certificates, which are public record for anyone to go see. So I don't know. Tell me your thoughts. What do you think is next? Really hoping that we can still get some kind of either accountability. And by accountability, I'm saying, Clayton couldn't hold Laura accountable. Or two, some kind of apology where Laura admits to all this fuckery and orchestrated bullshit. I really hope, ultimately, she can start 2024 off on a different foot and really get down to what is the impetus behind doing all these things and really hurting so many people in the process. And hurting people that she doesn't even know and who never will even know the story. Because like I've said, people will use this as something to point at to discount any and every victim. There's people who seek the Cassie and Diddy lawsuit and will be like, how do we know that she is not doing what this woman did? And that's what bothers me. Thank you again for watching. I can't believe it's almost the end of the holiday break for me. I am like staring down the barrel at Monday and I'm like, how did this just whole week go away? Like, how did it all go by so quickly? Part of me is like wanting to look at like what my PTO accrual is and be like, should I just take some more time off, because I feel like I'm not ready to go back to work. I've been doing lots of little artsy fartsy and creative things that really feed my soul in the holiday break so far, which has been so nice. I don't usually take time to do that because I have such a serious job that requires a lot from me, and that's why the topics on this channel are not really like getting into like the world events for the most part. It's supposed to be lighter, more topically discussed things, kind of to give me a break from the reality that I tend to live in my, I'd like to say 9 to 5, but sometimes it's really 9 to 7 or 9 to 9. So I'm like, oh, I wanted to get more little projects done and I can't believe it's almost the weekend. Let me know if you guys have any plans this weekend for the new year. I think I'm gonna go see a movie with my niece tomorrow. And I think on Sunday, we're going to go out and watch some live music as the ball drops. So that'll be fun. But thank you again for your kind words, your feedback, and tuning in to yet another video. I will catch you soon. And again, really appreciate every single person that has the patience to listen to my incoherent and sometimes stuttering thoughts. Thank you, and have a great one.